Okay, hey everybody. If you can hear me, put your hand up or something, or give a smile, something like that. Cool. Let me see if I can find. Okay, Thomas is here. Gonna make co-host. Thomas, I think I've sent you an invite that you need to accept. Okay, I can see Thomas. You're now a co-host.
Yo, hey Simon, how are you, man?
Yeah, good, thank you. All right. Thomas was a bit of a trooper, everybody. There was an AMA yesterday, which I think he did several hours with Plan C, and then I came in to listen in the end and hijacked a little bit. And Thomas had some really great experience. So just to set the frame, the topic of this AMA is really to have as much engagement as possible. I'll give you a brief intro, and then Thomas is just somebody that's got an amazing amount of experience at different bankruptcies, both crypto and traditional, and can answer those questions. He's not a lawyer, so he'll always give you a non-lawyer opinion. And I think maybe Jason might show up as well. Let's see if Jason Seibert's here. So he can do some lawyer stuff. But really, this is just an AMA to be as useful as possible and engage as much as possible. To clear up a lot of questions, I just can't keep up with the tweets anymore. And I think Thomas can't keep up with the DMs anymore. So we just thought, let's just go live. And it also just seems like a lot less confrontational when you're trying to answer in 140 characters. Sometimes it just comes across as confrontational, but really we're all focused on solutions at these stages. And when you speak, you don't get to see the white in the eyes of people, but you do get to hear the voice. So, and it seems to make a bit of a difference. So we're here to answer as many questions. To give you an update on recovery plans, and Thomas can give a bit of a, if you haven't met Thomas, he'll give a bit of background on some of his experiences and where we're at now. But I'll discuss to the recovery plans. So if you think back, God, how long ago was it? So I think Celsius suspended withdrawals on June the 12th, I think. So over a month ago, 6 weeks, wherever we are, it's been an absolute emotional roller coaster, and we've all shared a journey together. When I originally launched the Depositors first campaign, I talked about three approaches, and we've been through the journeys of each of those approaches. The first one was a way of recovering Celsius, much like I did with Bitfinex back in 2016. The dependencies upon that were that there was a business that could be recovered. And as we've shared this journey together, that got some resistance because I realized now that there was a business that couldn't be recovered because of everything that we later got revealed within the bankruptcy proceedings. So, that was let's launch a debt and equity mechanism, let's communicate, and let's plug a hole. And let's be transparent about that hole. And once you disclose those holes, you can then put together a plan and avoid the bankruptcy proceeding process, ideally, by solving it with the community. So that was part one, and then realized that wasn't going to happen. So we moved over to option two. Proposal two was I put together a syndicate of investors, had commitments for people that could write checks for up to $6 billion. And I needed disclosures on the financial situation of the company and some of the regulatory situation. And so when that was not being presented, I started to get a little bit more aggressive, and it became apparent that there was a lot more to this. And so I started ratcheting up on Twitter and sharing my belief that that this isn't illiquid, it's insolvent, and that there is a big hole, and that there has been activities that are going to hit the courts. And there's lots of things that are going to lead to lawsuits. And really, the community took it as FUD, and until it was proven. And then it became true with the bankruptcy proceedings. And so that's really the journey that we've been through. The bankruptcy really started to initially reveal the information that we needed to work and move over to proposal three. And proposal 3 is where we're at now, which is that it's scary to investors. They're not going to invest into Celsius, and I said there's 3 reasons why. One, the leadership means that we don't think that there's a recoverable business under the Celsius brand with the existing team. And secondly, that the risk model needs to be rebuilt from everything that we've learned. And thirdly, there needs to be all the licenses and regulations and a regulator that approves the plan, because when it goes to court, the committee will decide what plan is best. And then the court will determine whether it can actually legally operate. And so now we're at that phase 3 where we've put together a plan that allows that to happen. Now, the reason that we're doing that is because we believe that the plan that Celsius has announced, which will be developed further, we're actively engaging in that process to support them in developing it further as well. And as it develops further, eventually a committee is going to be in place by, I believe, the end of this week that will look at these different plans and proposals. And I initially thought that I wouldn't qualify for that because I've got various interests. As a ordinary shareholder, there has been a preferred shareholder, which were the Series B investors that have come forward. But it's very apparent that the ordinary shareholders have pretty much been wiped out as a result of all of this. And so the bankruptcy proceeding, and Thomas will talk to this a bit more, is really centered around getting the best result for creditors. So then, there's also other various things. But my legal counsel, which I haven't brought to, whenever I've brought, contacts of mine that know crypto law, they've come onto these. Those aren't my legal counsel. Anyone I'm bringing onto this, I haven't engaged. I'm not paying. And we have legal counsel that I wouldn't bring onto these because they're working with us on trying to put the depositors first and come up with the most effective strategy. So here's my belief, and then we'll hand over to Thomas, and then we'll just engage to answer some of your questions. In order to have an effective strategy, I believe that there is the money isn't there, so there is a haircut, and then the question comes, how do you make up that haircut? And so the proposal has been put that those that just want out and need the cash, and Celsius will put together an offer, and you'll settle. You'll agree not to sue them. You'll agree to all sorts of stuff, and then you'll settle. And whatever the haircut is, whether it's 50%, is whatever it is based upon market conditions and many other factors. And so you'll settle from that. Strategy that limits much of the liabilities for the company, and it's the type of strategy that a lawyer would recommend in order to limit many of the liabilities and protect some of the executives as part of, remember, they're engaged to do their job, so they're going to come up with a strategy that does what is the goal set by the board and set by the company. And so then you have that, and so then it becomes, what do you do in order to make up for that? And Celsius have come up with crypto long, and we can go a little bit deeper into that. We don't know the details yet. I've got some speculation about what I think crypto long means. And I believe it has different implications for those that have stable coins and those that hold crypto. Now, full disclosure, I'm a Bitcoin guy. So I got into this because I was deposit some Bitcoin, and then I can get a loan against my Bitcoin rather than selling it. And I can put some more Bitcoin in that would pay the interest on that loan, but it gives me exposure. So I would never put all my Bitcoins on the platform. But as we've learned, it became apparent that a lot of people, due to these misrepresentations, were putting all of their savings on the platform. And so, what is a future business? And Celsius have proposed this crypto long, which consists of a mining business, and I've been involved in mining from 2014. So I know how that business operates, and I know that it's a very capital intensive business that requires a lot of reinvestment and very low margin, a very efficient business as well. The difficulty, the way the Bitcoin is designed is to adjust based upon market conditions. So if the price of Bitcoin goes up, you get a 2-week head start. then a bunch of mining equipment goes on, and then the efficiency, the potential for profit deviates, and then you have to continually reinvest and raise capital in order to make that business work. So just calculating the number of Bitcoins based upon the representations that are in the bankruptcy and first day hearing presentation doesn't really give you the full picture of the opportunity to recover on that. And also, as somebody that holds Bitcoin, I'm not thinking in dollars. So remember, the advisors are all thinking in terms of dollars. So they're trying to fill a dollar hole. But the way that I think about it is I had Bitcoin, and that Bitcoin's going to be haircut. And no matter what happens to Bitcoin, I'm going to have less Bitcoin. So it doesn't really mean anything to me. Now, obviously, if you've got stable coins, that's a different scenario. If the market recovers, there might be money that's made on the crypto long, and then they manage to sell some of those cryptos on the way up, and that takes away some of their liabilities and gives the opportunity to do that. So that's their plan, and we would like to make sure that what we believe to be a way of making up for the shortfall. And the shortfall I cannot think of any other way other than equity in a company that has a future, which means that equity is illiquid, high risk, high return. So it means that if that happens, we share a journey together towards building a business that's compliant in the long term. And if that succeeds, we gave the best case at Bitfinex was some people got equity at $30. It ended up at $16. They spent 2 years paying out hundreds of millions in dividends as profits. And they also gave people a right on the Hacks recovery Bitcoin, which came back later, many years later this year, or potentially comes back this year. And that created a very high risk, high return opportunity. And we'd like to try and do that, but it would have to be done under the conditions that we think would have at least a shot of succeeding, which is new management, new brand, new regulatory license, and new risk model. And so I've been sharing some of those things. That brings us to where we are now. And so maybe Thomas, you could share a bit about, since it went into chapter 11, what's happened, and then let's just bring in as many questions as we can and just try and be as useful as we can.
Sure. Simon, thanks for having me. And this is really your show if you're working on getting a restructuring plan together. I'm really here as for technical details for free, because as Simon said, I'm not a lawyer. My parents, unfortunately, are bankruptcy lawyers, so I grew up hanging out around the bankruptcy court with I used to hang out with U.S. trustees and hanging outside 341 meetings. So if anyone is a bankruptcy or legal nerd, you'll know this is what I spend time doing, basically waiting for my mom to get out of 341 meetings, which are the creditor meetings early in the case. So where are we? You've had the first day motions. Almost all of them been granted without much fuss, which is very traditional. There's always some pushback from the United States Trustee's office. One of the biggest pushbacks from the judge, and why a lot of those all the first day motions are only granted on an interim basis, is not everybody has had the time to tool up, hire counsel, decide what they have problems with, in terms of what the debtor's saying in the first day hearing they want to do, accomplish, and or motions that they've asked to be approved. So the judge grants them on an interim basis. And I don't know when it'll be, but probably, I think the interim basis, I actually don't know the length of an interim basis motion on those, but they'll come back to court and call it a month or two and try to get final approval on some of the stuff. And again, the other reason is because the Unsecured Creditors Committee, as Simon was saying, has not been formed, which it always takes time, right? You got to find people, you want to vet the people, see who's eligible and qualified, and also who you think is going to put in the time, because it's kind of a thankless job to be on a creditors committee. You don't get paid. You have a responsibility to all the creditors. You're not supposed to look up your own interest. So it's a thankless job. I've been on a few. It's kind of fun, but it's also a lot of work. In this case, again, there's going to be tons of new case law when it comes to crypto and, bankruptcy code and what that means. A lot of in all the letters on the docket kind of highlight that. There's all these little nuances that's kind of the next step. So First step was first day motions, very traditional stuff. And we get a highlight of what the current state of affairs of the company looks like. We'll get more and more detail as the financial schedules are filed, I think in 40 or 45 days. And now we're starting to see I think the second cut is going to be dealing with all these letters that were filed. Not to say that, and I should say that I would get in trouble from people I know telling people to write letters in. You should really try to do things in the formal court process way, but people feel compelled to do this sort of stuff. And, it does highlight some of the problems that need to be addressed very, very swiftly, either by the debtor or the UCC when it's appointed, hopefully by the end of the week. And you'll see, just like in Voyager, they'll put the name and probably the email, just like in Voyager, of the UCC members on the docket. You'll see it on the docket. So you can always look to the docket, just like the letters. The judge doesn't want emails to him. He says, "Fine, file it on the docket so everyone can see it." Those do help highlight problems, but I wouldn't say that's like the best course of action. But it does help highlight problems to the court. I would say try to channel it through the debtors counsel and try to channel it through the UCC when it's formed. So I would stop there and just say, so the next cut is dealing with all these tricky issues, which is people don't want to either meet a margin call or pay off their loan when it's due because they feel like they're putting good money after bad because they're sort of paying off a loan that then now they're, one gentleman was saying he has 4x collateral coverage. Why am I throwing good money after bad? Now, the debtor did say in the first day first day hearing that they're going to pause, as much as they can. So, like on the loans that we're talking about, basically, I don't think pausing the maturity is strong, but like they're not going to liquidate out people's collateral if they don't pay at maturity. And this is not legal advice, but anybody who was on the hearing, please either correct the record here or confirm it. That would be great. But those are the little tricky questions that are coming up, and I'll stop there, and maybe we'll start opening it up to questions.
Cool. We've also got Jason who listened into the hearing and was
Jason,
providing commentary.
That's what they said, right, yesterday? Correct me if I'm wrong here, please.
So I think it was 6 or 7 different attorneys that spoke for Kirkland on behalf of Celsius. So if I'm pulling back in my recollection, I think it was Mr. Nash who addressed the court at the beginning and went through their pitch deck, right? And the general gist that they were trying to convey in order to, I think, appropriately appease the court and the trustee was that they were trying to maintain the operations in a way that was supposed to bring in outstanding assets or various notes or products that Celsius had invested in as Celsius in other platforms to effectively recall collateral, right? And that any of the loan activity or any of the people that were lending in the Celsius platform that may have outstanding obligations, I understood that they were agreeing that those assets would not be touched, and that they were going to effectively try to wait for the unsecured creditors committee, what's been referred to a few times as the UCC, not to be confused for other lawyers out there with the Uniform Commercial Code, which is a different section of secured credit. But I really think nothing should be anticipated to be done until the creditors committee is formed. And the reason being is that, under the reorganization under 11, you're supposed to be managing the business in the best way for it to move forward, and that's why I was a little. I'm gonna switch gears and talk about the mining operation. That's why I was a little taken back when the judge, even though the trustee said, it may be prudent to wait for the creditors committee to weigh in on whether or not company assets and resources should be put forward for an expansion of a mining facility, right? They already said that 3 locations were up and running. They already had these systems up and running, that this was for an expansion, that there was already revenue coming in. And there was no argument that was made that it was a business necessity to continue building. But I don't know if the judge picked up on that or not. Regardless, he agreed for the $5+ million to continue construction, even though the trustee said that that should be a business decision on whether or not the company is going to move forward, left up to the creditors committee to weigh in on. Whether it was a right decision or not doesn't really matter. As to the loans and what should happen to that collateral, I think rightfully so, they're going to wait for the creditors committee to weigh in on how to proceed with that.
Jason, just so like from being involved in a ton of bankruptcies, it is kind of weird for a debtor to show up on day one where no one has attorneys hired, or they're just in the selection process. There's no unsecured creditors committee, and they're asking for capital to be put into a business expansion. And so,
yeah, that was odd. And I think this is kind of a tip of the hat to Kirkland and their attorneys, and that they didn't really reveal, I think, the circumstances of the scenario, which is the mining operation exists and is operating, and doesn't need this construction or these pieces of equipment for it to continue to operate. Right?
I don't know about that. I think the debtor was trying to make potentially that murky, so they got the relief they sought. But yeah,
well, they said that, this has been allocated. These were critical vendors, right? They put critical vendors, and the judge asked, okay, or the trustee at least pushed back, why is this money going to the mining operation, to a subsidiary, and not to a construction company or somebody else? Why is it critical that you pay yourself? Was the question.
Well,
the response was build it out.
Okay.
And
I think one of the fair point or pushback from the debtor would be, well, it's in our business judgment that we're receiving these miners in the future that we prepaid for, and we need somewhere to put them. And if we don't do the expansion, we won't have anywhere to put the miners. I think that would have been the better response, but Mr. Nash was probably off.
I think for $500 a month, you can get storage facilities in this remote location in Texas where you can keep those mining rigs. You don't have to build out a $3 million expansion to house them. So that's just me kind of, being a frugal and prudent person. At the end, I think mining is a good segment for Celsius to be involved in. I was just taken aback by, the court granting an expansion on day one without having, the committee formed yet. That's all.
Well, it's interim relief, Jason. So like they can always come back. The UCC can basically not have final. And now the $3 million will be gone, but that'll be the end of it. And the $3 million spent hopefully has some value that will come back to creditors in the sense of you've invested in this, and now the replacement cost of whatever you invested in is that much more. But what's interesting is people that are more crypto miner focused or in crypto. I would have thought the reason that the debtor got into the crypto business, into the miner business, is to basically generate Bitcoin yield for their customer set. So it's interesting to me that you guys are saying it is a different business, and I can appreciate that because it seems like a infrastructure game of capital where the biggest dog basically has the lowest cost of capital, probably the lowest energy cost because they can push around the not the providers, but just basically, it's a game of scale. And so can anyone, and Simon, you were kind of going on this, but is that why they got into the business, was to basically generate yield on Bitcoin?
This is when I look back. So firstly, there's two things that I'm interested in. Firstly is going back and trying to figure out how that deal was done. So if Celsius acquired that mining company because they announced a press release of a $200 million acquisition, If the founders sold that to Celsius for equity, then their equity has probably just been wiped out. So the founders of the mining operation may potentially become somebody that wants to file a lawsuit in the future. I don't know. But maybe they bought it in cash, and so the cash came out, or maybe it was a combination of both. I'd like to understand a bit more about that. Then where I started to question Celsius about their peer-to-peer model was when they started to say that there's 6 ways of generating yield. As I went back through the videos and people started to send me these AMA recordings. I'm assuming one of them was mining, or that was the goal. And this is when I started to get a little bit concerned that if there's 6 ways of generating a yield, you're no longer a peer-to-peer lending model with you're now a security. And now you're putting together 6 different ways of making money. And where's the disclosures of what you're doing with those funds, suitability, securities law compliance? And that was really the first telltale sign for me. If you're investing, so we put together a mining backed security in 2014, and that was a full prospectus around our mining rig in Iceland, and we paid out daily dividends in Bitcoin. So we built the infrastructure in order to do that. We paid out thousands of Bitcoin. Bitcoin is about $250, I think, at the time. We built that infrastructure, and it was a very profitable investment. But when we analyzed it versus just taking the money and buying Bitcoin, it was kind of the same result. And so it's interesting to when you're analyzing a mining operation, this debate is as old as time. From podcasts years ago, we were talking about, well, what if you just buy and held Bitcoin and you didn't have to go through all that operation and reinvestment and capital intensity? And so the question will come, is it better to sell the mining operation to someone that does it by business and then just buy Bitcoin if you're doing crypto long? Or should they continue to operate and reinvest into a capital intensive business that generates Bitcoins? That will be, there's been IPOs that have been, had to do that analysis. I remember an Australian company called Bitcoin Group tried to do an IPO for this, and ASIC, the Australian regulator, made them do a full-blown analysis. The number of variables in trying to model these things out are incredibly tricky and incredibly challenging. So yeah, those are the types of things I'm thinking about in the mining side. Cool.
Yeah.
Why don't we bring a few people in and we can ask some questions? I'm just going to invite the top 3 people in, and you can ask some questions. So if you've just seen that you've been invited, hello.
Hello.
I just brought 3 people in.
Hello. This is Leo.
Hello.
Let me hear you.
Yeah. Okay. Thank you for putting together this AMA. I have one question for Simon and maybe one for Thomas or Jason. The one for Simon is, in your plan that you're gonna propose, I understand it's gonna be done through BnkToTheFuture. So for those that are non-accredited investors in the US, will they have the opportunity to participate?
So this is a good question. So firstly, I won't reveal the structure, but we came up with a structure where we could, which I'm just getting signed off by compliance legal, and then our broker-dealer will take that to FINRA and get sign-off on what they think about that model. The second thing is, when we were speaking with Thomas yesterday, and this would be interesting to get Jason's opinion on it as well, is Thomas has seen cases where shares have been issued to non-accredited US investors because it's not actually an offering. You're not actually, you can't go out and raise capital because that would be an offering. And so when we're going to inject capital into the entity, and that would have to be in compliance with securities laws. And if we do it from US investors, we probably won't. But if we do, then we'd have to file a Form D and follow our usual process and go through our US broker dealer and use certain exemptions, which would require it to be accredited. But issuing shares in a Chapter 11, Thomas has said that he's actually seen that, and that's not actually a securities offering. That's just issuing shares. So there'd have to be. We will do that analysis, and if that has been done before, we'd look to see if we could use that as a compliant way of issuing shares to non-accredited US. Thomas, do you want to talk to that?
Yeah, so there's a thing called 1145 of the Bankruptcy Code. It allows you of course it gets very technical, but you're allowed to basically take someone's claim and mutate it into a different security. Now, and there's an exemption, even though that would technically be like, an offering, there's an exemption, and the exemption is 1145 of the Bankruptcy Code. So if you just Google 1145 Bankruptcy Code, the first thing that'll pop up will answer that. Now, that only allows you to issue securities in exchange for what they already own, but you can't allow someone to invest new dollars, I believe. If you invest new dollars, then you have to be accredited, or you have to follow the usual securities laws. And I don't know, Jason, if you have anything to add to that, or if you're familiar with 1145. But
yeah, no. So you've hit the high level of it that I think is appropriate for this venue. We could go into 1145 and the nuances of the 33 Act all day long, but I think for purposes of this discussion, the end result is yes, it is possible for a debtor to issue securities under 1145 under an exemption from securities laws. And if you look at 11 U.S. Code Section 1145, the title of that subchapter is exemption from securities laws. And we'll just leave it to the folks to go out and search that themselves and read through that. But I don't think going in or spending 30 minutes talking about the nuances of it is really going to be of any benefit at this time.
Yeah, so the point is that we know of two different methodologies, and a third would be, there are ways of offering securities to non-accredited investors, but that's a timely process. That involves Reg A pluses and various other things, which we have done before as well. So one of our portfolio companies, Exodus, they did a Reg A plus for a security token recently. And some of our portfolio companies have gone public, like Circle's doing it via a SPAC, Coinbase went public, Robinhood went public, Ripple Labs is involved in. Yeah,
I think one of the things that, and sorry, I just wanted to bring this up. There is a limitation on how many shares you can offer. You're not allowed to just
2,000 shareholders, right?
The percentage of shares outstanding at a certain point. There's limitations on the percentage of how much you can dilute effectively, right? So that okay. Again, without going into those nuances, Celsius is not going to be able to say we are going to replace all of our debt with equity because 1145 allows us to. No, there's limitations on how much of that can be a part of the plan. That's all I wanted to convey.
Mm-hmm. So the point is that the court, we would need to demonstrate to the court that this is compliant, and we're working through those processes, and our goal is to try and create a mechanism where we don't have to have these people treated differently, if we can, and that's part of the plan, and that's what we're trying to get signed off.
Yeah, and I love the spirit of it because try to create an opportunity out of this mess. I think it's a great. Obviously, you mentioned that it has high risk, but for those that would like to participate, I think it's a great opportunity. Now, the other question is for whoever wants to take it. I'm a Celsius. I've been a Celsius customer for quite some time. I'm a Bitcoiner like you, Simon. I have all my Bitcoin in cold storage, multi-sig, because I believe in cold storage. However, I thought I like the proposition of Celsius in the loan programs, right? So I had a lot of altcoins from 2016, 17 that I would, I thought about converting them to BTC, which now looking backwards, I should have done that. But instead of doing that and pay taxes, I decided to bring them into Celsius. Okay. So I don't have any BTC in Celsius, maybe just $15, but I have most of them in altcoins. I'm not gonna say the other word just to be respectful, but my question comes in. There's people that have different type of coins and stable coins in earn accounts. There's also those that have in custody accounts, and we've learned in the process that sometimes the custody accounts were managed differently. But then you have the collateral on the loans. So my question to anybody could answer is, if you have an earn account, your agreement with Celsius was, I bring this money and I get a yield, right? Now, if you loan your money, and hopefully I speak for everybody that has a loan, the agreement is sort of like, I give this collateral, I give this money back, and then when I pay back, I should release the collateral, right? But why is it possible that you, even if you pay off your loan, you cannot take the collateral? And I don't really understand that, because if that was the agreement, we've seen Celsius that have been paying DeFi loans to get the collateral back because they have 1.5 and they never had any problem with unlocking the collateral. So why regular customers, they cannot get the collateral back if they decide to pay off the loan? I understand, Celsius can say we don't have it, but I would like to understand by law why that is not possible.
So this is Jason. I was trying to follow along to your questions and concerns, and you asked so many different compound questions in there. I'm not quite sure to start. Could you help me out by narrowing your question down to one specific thing first that I can try to address?
Let me try and deconstruct a bit. So I think the first part.
Thanks, Simon.
Was,
I mean, when somebody says, "I want to know what the law says about that," I have to be careful how I answer. I'm like, what exactly was the question? So
okay,
go ahead,
so
Simon.
We got three. Yeah. Okay, we got three layers: custody, earn, and collateral. So, and earn and collateral come together, I guess. So, from my perspective, the way that I'm thinking about this is, if you put up collateral and you want to get a loan, then in the future, I believe that has to be done under a consumer credit license, which is what BlockFi has and Celsius doesn't have. That's a regulatory part, and then we'll deconstruct. Custody is they do not own the coins, they're holding them for you. So if it's done via a trust or however it's done, legal title to those assets should be in the name of the person, and those assets should not sit as a company asset on the financials of the company. And then you have earn, which from my perspective is a security, which is we'll pay you yield in exchange for things that we do with your money. So you've got these three different services and these three different regulated services. Are they all going to be treated differently in the bankruptcy? Well, here's where a bit of transparency and understanding of what happened. And that can only come from disclosures. So the first thing we don't know is we don't know what the balances of all these tokens are that Celsius has. That's required in order to put together a recovery plan and a financial model. How many ETH is owed to customers and how many do they have, and break that down token by token. And then, did they actually treat the relationships in the legal way it was meant to be? So if it was custody, in theory, that's not a company asset. That's a client's asset. Now, my understanding of how this happened is it was a regulatory fix, that they were being investigated by state regulators and the SEC, and they determined that they can't offer securities to non-accredited investors. And their fix for that, as they were trying to negotiate a settlement, was to make them put them in a custody account. Now, whether those assets actually get transferred to a custody account, and they did buy a company, GK8, which is a custodian, but my understanding of that is this is a technology company. It's not a regulations company. It didn't have licenses to be a custodian. So did they do it properly? And then the answer to what I think your question is how is it possible that I took out a loan with collateral, and if I get that back, do I get everything back, or do I get a haircut? This is the mismanagement of finances that is currently happening. My belief and my opinion, and I don't know until this is confirmed, is that they simply just took this ginormous pool of money and invested it, and they didn't separate custody, and so therefore it's just a question of they were trying to unwind everything, figure out what they got, and then figure out how to plug the hole. And then I think this comes into something that maybe Jason could give color on the legal side, and Thomas could give color on the bankruptcy side. Who's an unsecured, who's a secured, who's a custody? I think these are all legal issues that are going to be debated in the court. Maybe that helps.
Right. So this is Jason. If we start under the first category that you had, were the folks that propped up collateral in order to receive a loan, right? That's a very specific type of transaction. I agree. That's a different set of regulations than someone who has claimed via custody or has been designated as custody, where now there's some form of fiduciary duty that may be imparted upon Celsius to care prudently and reasonably for somebody's property that they have in custody. And then finally, the earned rewards program, which multiple state regulators going back to last year had determined was an investment contract and had ordered Celsius to cease and desist on. So I'm going to take up number two, which is the question of what happens with custody. And I know we talked about this in the post-hearing show that we did, Simon, on kind of the recap. But one of the things that Celsius punted to was they were not willing to say or admit within the record in their initial filings that those funds that are designated custody are actually ownership of the account holders. They stated to the judge that was going to be up to the judge to make a legal determination of the status and designation of those funds. And so I think any argument or any determination of that is going to be a little bit down the line. The creditors committee needs to be formed. They need to be allowed to brief and argue what they believe should happen with that. That said, there was a representation that the custody accounts only made up 180 million of assets, and they represented that those were set aside even though they were commingled. So that's the status. As for the earned programs, one of the things that the creditors committee is going to have to focus on is the data and the discovery that they receive from Celsius, probably in combination with an investigation that's going to be carried out by the creditor committee's counsel and their team to really look in and dig into that, coinciding with any investigation that the trustee may take in connection with disclosures that are given. What was clear is that the amount of information and data that the trustee had received thus far from Celsius was inadequate. And again, we talked about this the other day. For a first day hearing, that's fairly standard for the debtor to not have everything that the trustee and the court wants. So hopefully that addresses and answers those questions. If not, I'll gladly take a follow-up.
You got anything you want to add, Thomas? So in a nutshell, like, the money's not there and it's all commingled is my understanding. And therefore, there's a whole load of things to determine that is the reason why you're confused.
Well, we don't know that status yet. There's rumor that it's not there. There's an admission that it's commingled, but we don't know how much is commingled, and we don't know in what form, right? So there's a lot of things that we don't know, and that can be very frustrating at this stage when a lot of people that have suffered a lot of harm want answers, and they want them now, right?
Thank you.
And just on the custody question, I mean, maybe I'm overthinking it, but I think the debtor, it's not that they didn't think they were held in custody. They said it sounded like they were uncomfortable to basically sort of go filing a motion themselves without a declaratory judgment from the judge, which kind of makes sense. I mean, it's like, there's a lot of assets. It's not like they're returning a few $1 million. It is $180 million. And they seem to intimate that they just wanted the judge to,
So I have a suspicion that 180 million actually might be a larger number.
Yeah.
Because I think what they've done here in their reporting is they've said we've got this non-accredited investor custody category, and this is speculation on my part, right? I would need to see more. But what they didn't address is how many people were in the Earn Rewards program, right, after the April separation date that also have funds in custody.
Right.
And what's the legal determination for them, right? So I think to that extent, we're going to need to see more information. Yeah, Plenty, go.
Yeah, I think it's a lot more complicated because also you do have people that, from my understanding, you have people that actually were able to move funds after the freeze. Even though everything was technically supposed to be frozen, there were people that moved, in my understanding, again, I could be wrong, from earn to custody, and that was done through customer support. So if they overrode that and did that, I mean, again, these are issues because you can't favor anyone in Chapter 11. You can't. Obviously, everyone would have wanted to move from earn to custody given the chance after the freeze.
Had they known that there was going to be this carve out, right?
Yeah, so, that's what I'm saying. It's way more complicated. This whole custody thing, it gets really murky.
Absolutely, which means, there needs to be discovery and forensic analysis of Celsius's database entries to determine exactly when certain transactions took place, right? Because when you're talking about internal designations on a company platform, those are not recorded in a blockchain somewhere for public disclosure. So, we have to dig into their database and administrative systems. I say we from the perspective of, the creditors committee, which I'm not on, but I'm using the we in that scenario. They have to have the opportunity to be able to look into it and do the analysis, probably get a forensic database engineer in order to do those designations and parse that out, which will then help divvy up creditors into appropriate tranches of claims. And it's not going to be until there's a true designation of tranches of creditors and what their standing is and what their position is. Until that happens, there's not going to be any relief for anyone, right? That may take some time.
Jason, last question, do you know how the law would normally work? Would it normally be that it counts on the day that the bankruptcy was filed, or would it be on the day that the accounts were frozen?
So these are there's two different dates, right? So if this was tort, and I was to say that I was a customer and they denied me access to my funds, the date of my harm is the day that they deny me access. So that's arguably sometime between the 10th and the 13th of June, somewhere in there, right? Because prior to the June 12th announcement, there were people that were trying to get things off that were denied. We know this to be true. So even though on the 10th they made or was it was the 7th, right? The full speed ahead announcement, trying to get people to not remove their funds. There were people that were trying, some were allowed, some weren't. We don't know why. But those that weren't, they would have a claim from whatever day or time it was that they couldn't access their funds. However, when the trustee and the bankruptcy court looks at valuation, they look at their starting time as of the date of the filing of bankruptcy. So there's two different dates. And, you know, the difference in value between June 12th and July 12th, based on the overall crypto market, you know, for the most part, crab walking sideways, shouldn't be that significant of a change of value.
Yeah, I just wonder if, like, again, this is my speculation, but if insiders knew that Celsius was headed towards bankruptcy, and there are people that had over $10 million or multiple millions of dollars in the app, and if they told people, oh, you know, because okay, let me explain quickly. So there's really high net worth individuals within Celsius that had designated advisors that actually knew what was going on within the company. So these advisors of these high net worth individuals that would speak to them on a regular basis, if they knew Celsius was headed towards Chapter 11 and they advised their client, you should move your funds to custody, and they worked with, administrators within the company to make these moves before the bankruptcy, that's an issue. That is an absolute issue. You know, to favor these higher net worth individuals and give them inside information. I'm not saying this happened, but it's something that needs to be looked into, in my opinion.
Cool. Should we bring some more questions in? I let a few more people in.
Hey, Simon, John here. Simon, Thomas, thank you guys so much for hosting this. My question is two parts. I'm hearing some feedback. I don't know if you guys can hear that too.
Yeah, I'm getting a bit of a double voice, but carry on.
All right. Anyways,
hold on one second. Okay, they did. I had identified who the speaker was. That had their. We had a hot mic. That's all. Sorry, John.
Yeah, hot mic. So my question is two parts. One is, Simon or Thomas or Jason, can you tell me a little bit more about the Creditors Committee, how that's formed, who's designated to represent the community in that regard? And second of all, Simon, I believe, if I'm not mistaken, at the beginning of the AMA, you had mentioned that, to your surprise, given the level of interest you have in Celsius, that you could be on that committee. Would you be issuing a proposal from BnkToTheFuture, your proposal, via that committee, or would that be separate?
Yeah, I'll answer to the second question, and you guys can talk about the committee process. I've just been advised by my counsel, and I don't want to go too deep into it, that they've figured out a way where I can apply to be on the committee. And so I'm applying. They may I'll get a call, and they may decide that I'm not on the committee, or they may accept me on the committee. But they have told me that there is a way of managing certain conflicts, and there is a way of applying, and then maybe Thomas can talk to who would actually decide whether I'm on the committee or not.
Yeah, so the U.S. trustee decides. You know, the only thing I think, Simon, and you know, I'm not going to, they try to have is plain vanilla, diverse. Well, plain vanilla meaning they try not to have too many people with divergent interest in being other than being a pure creditor. But there's nothing wrong. I mean, there are a few famous cases where someone was on the Unscrewed Creditors Committee and they proposed a plan, or a plan sponsor is the way that people call it, the plan sponsor. And then there are other instances as well where people were on the committee and they were the DIP financer to the debtor in possession financer to, which is also called a DIP financer, to the company. Those are allowed as long as they're the best offer on the table. and they're not allowed to use their position on the committee for their own sort of purposes. So, if you were on the committee and you were proposing a plan, there's certain conversations where you need to basically be recusing yourself. Just like if you were on the board and, the company, for whatever reason was going to hire someone that was related to you, you would say, well, of course, I'm not going to be part of this vote or discussion because I'm actually the person that's proposing this. Well, that's different. But the idea is, whenever there's a conflict of interest, you should be sort of sitting out of the vote on that and probably discussion.
It works like that in our company. We have a conflicts of interest policy within our company, and we have to sit out on certain decisions where there's a conflict. So, most regulated financial institutions have to operate to these types of standards, and so we'll see if we can navigate that. I think I've been doing a reasonable job. I may have got some things wrong, but on Twitter of disclosing, saying when it's an opinion, trying to point out conflicts of interest, which is incredibly challenging on 140 characters. But it is something that I'm used to, and our counsel said that they think I can apply. So one of the things around that analysis was I'm a part of the Series A, and I'm CEO of a company that pulled together a syndicate for the Series A. And there's an opinion that the equity value has been wiped out by Celsius's actions. And part of there's somebody that wants to join the creditors community as the preferred shareholders. And so they have different rights. And so as I'm not a preferred shareholder, I don't want to butcher the analysis, but counsel has said that it's worth me applying. And certain members of the board at Celsius suggested that they'd like me on the committee, and so I'm putting it forward, and I'll just disclose all my interests, and I think the US trustee will decide whether I add value or not, or whether there's a conflict or not, or whether I add complications or not. It's not my decision. I'm just applying.
Great, guys. Thank you so much for that, and I'll step down now.
Thank you.
Cool. Does anyone else want to get a question? If not, we'll invite some more people in. Who have we got here? Okay. I'm going to let some more people in. So I'm going to let the next 3 people in the queue. Hopefully it notifies you. And speak up if one of you has just been let in.
For letting me in. Can you hear me?
Yeah, we can hear you.
All right. So I'm from the other side of the pond. So I was wondering, are the rules different for me than for people in the United States?
Sorry, where do you reside?
In Europe.
Okay, so asking if the rules are different for you than somebody in the United States, very broad and vague question. What can you narrow your concern down a little bit?
Probably concerning. Is
it in relation to issuing equity in a bail-in, or is it in relation to your services to Celsius?
Yeah.
So English is not my my main language, so I'm just trying to understand everything that's going on.
Let me ask you some questions then. Is it in? Are you inquiring whether you will be treated differently in relation to some of the services that you have with Celsius as a creditor?
I guess that's part of my question. Yeah.
Let's back up and ask a few more preparatory questions there. Are you a customer or a user of Celsius?
I am.
Okay, and in what way did you use it? Did you take out loans, or did you provide assets to the platform for them to lend so that you would earn rewards?
Yeah, I
you were
going to. Yeah.
All right, and are your coins on the platform right now? Are they in the Earn Rewards program, or are they in a custodial account?
Earn Rewards.
Okay, very good. Thanks. That kind of narrows down your perspective and where you're coming from.
Thank you.
So go ahead and ask your question then.
If whatever the outcome may be, whether it's the plan from Simon or any other plan, are the rules or the payout different for people in the United States or anywhere else in the world, basically?
Yeah, so if that is, this comes down to the nuance of securities. So from my perspective, whether this is true or not, but you've invested in a security, and if you're an EU resident, then you'd normally have a prospectus if you're raising more than 8 million euros. And also the jurisdiction that you reside in will have your local securities laws as well. And so whether EU gets in on the action or your local regulator gets in on the action will determine whether you should have been treated differently or not. But then that's just the offering. Now, if there is a carve out that we'll be looking into, where we can issue shares in Chapter 11, which would then bring in a contract into the US courts, then I think that the whole US versus non-US is something that's resolvable. Accredited versus non-accredited is something that's resolvable. And BnkToTheFuture, we're very familiar with doing securities offering in both the US and Europe. So we have the tools to cater for that. Now, I'm hoping that our analysis will say that this isn't a securities offering, and it's in fact issuing shares. And we've got a plan for both. So unfortunately, I can't give you an answer until legal compliance and regulators sign off. But my goal is to make it where there isn't a difference.
So the short answer to your question is, depending upon the outcome of how the Chapter 11 restructures Celsius, because of your jurisdiction, you may be treated differently than a U.S. resident who may or may not have the same regulatory regime over them for the solution.
Can I? Yeah, I totally agree. Can I say it from a different angle? Other than the securities offering issue, the bankruptcy code itself does not treat foreign and domestic creditors any differently. There are many insolvency regimes around the world where local creditors are treated differently than foreign creditors, and that is not the case in the U.S. bankruptcy court.
Yeah, I got to say, I'm a huge fan of Chapter 11. This is my first involvement in this process. And compared to bankruptcy proceedings in places like the UK and stuff, this is seriously innovative, and I'm really grateful that they did this in the US, and you don't have this in other countries.
Yeah, well, so a lot of countries will try to copy the American system. I think empirically, if you look at there are actually bankruptcy academics that study this stuff, and if you look at recoveries, the American system is extremely high recoveries. I think it's because it's a very progressive system. Sometimes people don't like some of the progressive nature of it, whether it's employee retention bonuses or even debtor in possession processes. But the debtor in possession process has been incredibly successful for creditor recoveries, which is at the end of the day what everyone's concerned about. But there are a lot of arcane is the right way to describe these insolvency regimes around the world that are strange, really, really strange.
Yeah, Celsius has a UK parent, and I'm so glad that we're using Chapter 11 rather than the UK process, because the UK process would have been immediate liquidations, crash of the markets, cascading effects on other institutions, an effect on the mining industry. They could have crucified it. So I'm really grateful for Chapter 11 that we even have the opportunity to discuss this and involve the community in potential solutions.
So there was there was a question earlier today within the Telegram group of the Bankruptcy Ideas group that I try to check in on from time to time and answer questions when I can, and sometimes I'm not able to do that. But there was a question that somebody asked on what exactly has the judge or the trustee, how are they helping, or how are they going to help? And my response was there are so many different ways that they're helping. I can't go into them all, and I'm sort of paraphrasing there, right? It's Chapter 11 is a very good process for creditors in that it gives the more likely chance for a higher recovery rate than if it was just a liquidation. And so yeah, I think it is a better process than those around the world, or just a straight 7 liquidation. So hopefully it will stay in 11. And I was talking about this the other day. I really do think that there is a path forward for Celsius for success, and I truly hope that.
Great.
Yeah,
Who'd like to
and
take
I'll
a
say,
question?
Hi,
go
can I speak?
ahead. Sorry. Yeah, go.
Yes, yeah. So I just look. I'm just a normal person from Africa. Lawyers make things complicated. I actually don't like lawyers, but what they should do is they should get the judge to watch Alex's AMAs, and we believed in him, and basically he lied, and we put our life savings on his platform. It was a great company, and we thought the vision was fantastic to bring financial freedom. And just what he's done, I believe he should be held accountable, even go to jail. Yeah, that's just my thoughts. And then the second thought is, I just want to finish off with this. The best way I think to solve this is in South Africa or in Africa, there's a lot of crime and people rob houses and that. So what they do is they take a CD and they burn it. It becomes like an anesthetic effect. So what I think they should do is do it to Alex's house, get the keys for all the people's crypto and just pay it out to people. Maybe go steal his ledger or something and then just give our crypto back. Can we do that?
No, we can't do that.
No, we don't want to combat a crime with a crime. We want to use the legal system, and we want to use the lawyers here.
But in Africa, we do what we want, and we get away with it.
Actually,
Okay, so this is Jason. I'm gonna address this from a. I'm sorry you don't like lawyers. I like you. It's okay. It can be a one-way relationship. I agree with you that the judge should see the evidence of statements that were made. And I do believe that a judge at some point in time is going to look at that evidence in combination with trying to decide either if Mr. Mashinsky should stay on as leadership or if he should be removed. And or two, that information has already been looked at by a regulator and it will eventually be in front of a judge for determination of some form of either administrative, civil, or criminal penalty. So while that may not happen at the expedited rate that you want it to happen, those videos will be seen by a judge. Unfortunately, our process takes time.
If a judge watches those videos, he's going to want to invest himself and tell them to start to open the withdrawals.
So let's not presume what a judge is going to think, because it's all going to depend on the context in which they're being presented. They'd be presented as evidence and argued and then parsed. Now, the other thing that I want to say is that I just want to kind of nip in the bud any statements or any encouragement or any suggestions that anybody listening to this or hearing it later on should do any type of personal violence or harm to anybody's personal property at any point in time. Nobody that's speaking on this panel agrees with that, supports it, or would suggest that is a proper course. Do not do that, although that may be something that you believe is standard in Africa. That's not what we do here, and we specifically reject that notion.
If Alex did what he did and he was in Africa, he would have been taken out a long time ago. That's all I'm saying. It's just different, I understand the United States, there's laws and all this and that, but you don't do that to people's money and people's lives the way he acts.
Emotions are
anyway,
high.
cool.
Is there any question? We just, we don't. It's not going to
Now
be
the question,
productive to listen.
my question is, did Alex have the right intentions right from the beginning, or was he scamming people right from the beginning, or did he only scam people later because things fell apart? Thanks.
Well, I can give you my belief. My belief is that Alex got in completely over his head, and he was inappropriate for running a financial services company. And at some point, he realized that there was a problem. And in his way of deciding what's wrong or right, he didn't respect compliance enough to be a board member of a financial services company. And that may have worked very well for him in building a non-financial services company. But in financial services, you have to deal with a different level of standard when you're dealing with people's money. And I think Alex knows the responsibility and the consequences now, but I think on the way up, he just felt like he was building a high growth startup and he could trade his way out of any issue. I personally don't believe he set out to deliberately commit crimes. I think he found himself in something over his head, and then he didn't really know the severity of it, and then just carried on. And there's a lot of people that end up in operating Ponzi schemes that never started with the intention of operating a Ponzi scheme. These things can accidentally happen, and I'm not saying it is a Ponzi scheme. That's going to be determined. But these things can happen.
Let me just jump in just for a second, Simon. I think while I agree with you, this has been one of the things we've talked about quite a while in securities, ever since Bernie Madoff, right? Nobody really starts off intending to do a Ponzi scheme. There's a bad decision that's made at some point, and then a Ponzi evolves from that because the thought is that they can make up for mistakes along the way if they just had enough time. Where I think, just based on my viewing of some of the videos, is if it was known and seems to be hinted at by some of the filings that there were some, bad decisions made early on in which they tried to maneuver their way out of, that sort of code for we screwed up, we know we screwed up, and we've been backtracking ever since. I think if that was known to Mashinsky and Celsius, then Celsius as a whole should have been prohibiting Mashinsky from stating that the company was liquid and was in the position that it was. It would have been better to be silent than to say statements in the opposite, just from a fraud standpoint, if that makes sense.
And Jason, what are the ramifications of luring in new investors when you're insolvent? Because Alex was, putting promo codes on his Twitter saying, I'll give $1,000 to any new signups. This was within like a week prior to the collapse. I don't want to make this about bashing Alex. I want to, make this about constructive, moving forward. But legally, it just seems like there's a whole bunch of things here that could go against, and that would, maybe get rid of that 120-day exclusivity.
So, one of the terms that Thomas used earlier that I wanted to make sure that the listeners understood was the phrase debtor in possession. What that means under these circumstances is the debtor, Celsius, is in possession of the company assets, what have you. I think one of the first things that a creditors committee should consider is, what would be more appropriate? Pushing for a receiver to come in and take over. At that point, whoever the attorney is or the attorney's office is for the creditors counsel needs to be very adept and very well educated within the bankruptcy process for all of the remedies that are available, present those to the creditors committee, and then let them decide how best to move forward. I think speculating on what should happen or how it should happen at this point without having any of the information, any of the discovery, any of the documents, any of the evidence is probably just, it's a little premature. And while we want to know things now, unfortunately, I think just waiting a couple of weeks, we're going to know a whole heck of a lot more and be able to be better educated and make more reasonable and appropriate decisions. Yeah.
Okay. Anyone in that wants a question?
Yeah, I would like to speak. Ask a question.
Go for it.
Hey, how's everybody doing? I tried getting some answers from Celsius. I haven't gotten a reply back. I sent to.
I'm sorry. I'm gonna interrupt you. One of the things that we've been doing on these, and sorry, but one of the things that we've been doing on before somebody asks a question is we ask them to identify their stake, their position, their claim, relationship, etc. Could you just walk us briefly on what your status is with Celsius, please?
I have crypto and earn.
Yeah,
So
sure.
are you a depositor, a token holder?
I'm a sell token holder, depositor, yes.
And a shareholder?
No.
Okay, cool. Carry on.
Okay, me, I'm a depositor, and I've noticed that my funds are not in the custody or the earn program. They're in a withhold account, and I've emailed Celsius with a demand letter to return my funds because, according to their terms and services, my funds being not in the earn or loans is not subject to being unrecoverable if they go through liquidation or bankruptcy.
So they're in withheld status. Is that because prior to withdrawals being suspended, you requested a withdrawal, but it wasn't processed? Or
Yeah, but even before that whole shenanigan happened, it was already they were in the earn the most of my funds, and then when I did try to withdraw and they didn't, they were put within a withhold account. And prior to that, before the blow up, I was able to withdraw just a little bit as a test withdrawal. Some that was already in a withhold account.
So my guess, and I don't know the answer to that, is those that were close to the when they were implementing a suspension of withdrawals. Obviously, that would have been codes that they had to write, and so there would have been a time frame when they would have known that they're going to suspend withdrawals, but customers didn't. And so my guess is that they probably created this status for those that requested a withdrawal, but the code was about to or had been released to prevent people from withdrawing. And maybe you're stuck in that status. And I think that will be a status that will be debated in this process.
Yeah. Well, just to provide further information on that, I noticed that, I joined Celsius sometime in April, I think, before they stopped allowing new users to be in the earn program. And I always noticed that there was a withhold account from the beginning of when I started using the app. And I always had just a little bit in a withhold account, and it was never in the custody or the earn program. So then I always noticed that there was a withhold account from the beginning, from my experience of using it back in April 2020.
And you're a U.S. resident, right?
Yes, I'm a U.S. resident, and that happened all around the time of when they made those.
Yeah. So the user experience on my app as a non-U.S. resident, I think, is different from U.S. I don't know if anyone knows about this. I don't know about it.
Yeah, and then I tried to withdraw. Actually, the day of the announcement, but earlier in the day, and it was pending the entire day, and then eventually canceled after they made their announcement. And now the rest of my funds are in a withhold account. So neither custody nor earn or loan. And according to the terms of services, they should be recoverable. And then that's it. I was just sharing my status.
So just to be clear, I think Jason kind of highlighted that there's going to be some nuances probably around this declaratory judgment. Basically, the debtor's going to ask if they can return the custodial assets, and there's going to be some edge cases. I would say that you're an edge case in the UCC when they're appointed. One of the first things you need to start looking at is all these edge cases. like this withhold issue. Like, what is it? Is it custody? Whatnot.
Understood. I also wanted to ask, should people already file a claim through the Storeto's website, or is that something we should hold off on right now?
Let me take a stab at this one. This is Jason. So under Chapter 11, it is the debtor's duty to list their creditors and what their claims are. In this case, I think there's 300,000. So there is the distinct possibility when they do that listing, they may make errors in their listing of what your claims are. At which point you're going to have to sift through the data in order to find where your account is, what the claim is, if they got it right, if they didn't get it right. However, if you file a claim, which is voluntary, generally speaking, the court looks at your claim as the valid representation of that claim over what the debtor is going to list. So you can wait and file a claim as a correction, or you can file a claim ahead of time. There's no benefit to waiting. There's no burden to waiting. There's no benefit for filing. There's no burden to filing. The process is there to allow you to, effectively have a voice and say, this is what my claim is, and get it into the record. Or it's the ability to correct a mistaken claim filed by the debtor. So I'd leave it to you, to your own strategy, without giving legal advice on whether you should file or not file ahead of time. But those would be the reasons for filing a claim and when you would do that.
Okay, understood. Thanks. It was just like, it's kind of confusing because they said they're coming out with updated.
So with that, let Thomas try to dumb down my legalese there. Go ahead, Thomas.
No. They're coming out with a new form, they said, Jason. I don't know if you saw that, but some people posted it on Twitter, I think, as well. They're going to come out with a new form, so there's a section so you can put all your cryptos in. Because it was confusing. The form basically has like a one little slot where you're supposed to put in like the dollar amount. But honestly, guys, another thing people do is they will complete the proof of claim, and then like the headline number will be what it is in a dollar amount, and I think that requires that under the bankruptcy code. But we're gonna figure out like how the debtor's plan is going to emerge, whether it's Simon or someone else. I assume it's going to be really more crypto denominated. But a lot of people will attach schedules to the back of their proof of claim, so they'll like do it in a spreadsheet, like however they calculate their claim, and they just put the number in the line. But they're coming out with a new form that's supposed to make it a little easier. Like I posted it on Twitter. There was a case called Cred, which was a CFI project that filed, and yeah, the same thing happened. People were like, I don't know how to complete this because there's no space for all my different cryptos. So
yeah, and I think that's important. You don't even need to wait for the new form to come out. You can simply attach your schedule to the form with your dollar amount on front. Either way, the information is going to be in the record. So from a legal perspective or ramifications perspective, I don't suggest advising anybody when to file or how to file, other than this is what filings are used for, if that makes sense.
Cool. Let's take another question. If there's no question now, I'm going to let the next three people in. Okay, I'm going to let them in anyway. I'm just taking three people from the top. If any of you have got a question, jump in.
And I have outstanding loans. My question was, I have one of my loans is coming due on its term. I was wondering what the implications of extending that loan versus allowing the term to end and possibly have Celsius liquidate that to pay for it.
No, they said in the first day hearing that they're going to pause loan liquidations upon maturity. You should be okay. In the first day hearing yesterday, did you hear me? Or does that make sense? I just want to make sure.
Yeah, so I guess just letting the term end and then it'll be dealt with later.
Yeah, it sits there, and then it's going to be dealt with at a later time. The Kirkland was saying yesterday in court.
Okay, thank you.
Sure.
Okay, next question.
Sure, yeah, who's next?
Hey, Simon, thank you guys so much for doing this. I'm a depositor. I have loans. My question is for Simon based on what your plan is. And you speak a lot about being a Bitcoin believer. So I'm kind of wondering, is your plan, are you going to allow people that have altcoins maybe to convert to Bitcoin as soon as, because I'm guessing that you're not going to want to hold all these different alts and don't really see any value in building that part of the business out.
Yeah, so just from a business perspective, and again, my recovery plan hasn't been submitted, and I'm going to engage the community in getting lots of feedback because I don't think I've got all the answers, but I think the community does. But I will set some, if anyone wanted to join this business that we want, that I would try and put a team together to operate. Then my philosophy is that only dollar-backed stable coins and Bitcoin should be used as collateral. If people want to do a staking business, that's a separate business. And as you go further down the risk curve, you create complexities that you can't react to or forecast fast enough. So the Luna situation, what I learned from that is that if you can't pull out the dollars, it can depeg, and then you end up trying to figure out how to manage that scenario. And so that's one set of risk management that you need to figure out. With Cell Token, when you had collateral in Cell, then you're like trying to figure out, well, what if there's not enough liquidity and the token crashes? Okay, that's another attack vector. Then you start going further down. Well, what if ETH doesn't successfully convert from proof of work to proof of stake? What does that mean? And as somebody that's a shareholder in multiple exchanges, I know the immense number of complexities that happen as you go further down this, and the more you add, the more attack vectors you create. And so I just think there's a really nice clean business model in allowing people that don't want to sell their Bitcoin to be able to borrow from it, and also the stablecoin side. And I don't want to go and this is a risk management. So as somebody that has learned, and again, it's unfortunately Celsius has taught everyone a whole bunch of lessons. I'm not claiming that I would have come up to these conclusions on my own, but in these disasters, you learn things, and that's what I've learned. And so I think there's an incredible business in putting together retirement plans, educational wealth management programs that we've created, securities, and lending. And the three pillars is that you got to have leadership that really is a culture of disclosure and a culture of transparency, not just saying it, but making sure that everyone understands what they invest in and they understand the risks. The second cornerstone is risk management, and I think that would be what I would try and present as a feasible, viable risk management strategy. And the third is regulatory compliance, and I believe that it involves lending license, securities licenses, and those would be the three pillars that would make up the foundation of what I think could be a brilliant business. And I think that just focusing on Bitcoin and dollar-backed stable coins, and maybe the furthest down the risk curve you go is figuring out what happens with staking once Ethereum's transition to proof of stake. So then there would just be a transition phase, and I'd look to get community feedback on how to manage that transition, and eventually just transition to a business model that doesn't have all the risk, and leave that to people that want to speculate on that on exchanges or DeFi contracts. The benefit of DeFi is that you have to be a pretty sophisticated user to engage in a DeFi contract. When you put CeFi on top of it, you've kind of end up with this situation where people might not actually understand what's happening there. And the complexity is like at BnkToTheFuture, it's a harder onboarding experience than at Celsius. And customers get pissed off with us all the time. But it's harder for a reason, because we only want the people that genuinely want to invest in securities and understand these products and have passed the quizzes and suitability. And then if you get through that, then you genuinely wanted to invest in this product. And in startup world, you're just trying to get the easiest user experience for customer acquisition and affiliate programs. And when you add all that to financial services, you end up with the Celsius scenario. So
So Simon, the other thing to think about from the risk matrix of engaging in certain products that Celsius may have provided exposure to before, or not only provided exposure to, but exposed customer assets to, are these algorithmic-backed stablecoin offerings. Just like subprime mortgage, these were financial ticking time bombs, and there is some discussion within the regulatory enforcement agencies that those types of stablecoins are inherently, as themselves, investment contracts, and that the purchase or trade in those types of algorithmic stablecoins would be a security. And so any platform that's looking at continuing to offer these types of products like Luna, which is specifically designed to create, or was specifically designed to create, an arbitrage opportunity, means that the reason people were buying it was not to have some form of stability, but in order to take advantage or try to take advantage of some arbitrage play. So within that, without saying anything determinative about any specific algorithmic stablecoin, the message I'm trying to convey is that those types of assets, if Celsius is going to be a regulated and legitimate platform moving forward, may not be able to offer those.
Simon, I wanted to ask you, before you invested in Celsius, did you read their terms and conditions? And if you did you understand them? And why would you put your money in there? Because you sound very smart. I mean, reading those terms and conditions.
I didn't read the terms and conditions, and I put my money in because I believe that this was a peer-to-peer model, and I was comfortable with the risk, and I only put an amount in that I was willing to lose, and so that's why I did it. And my premise was, can I take out $1 loan without selling my Bitcoin, and how much Bitcoin am I willing to risk to do that? And then how much Bitcoin am I willing to risk in order to earn enough yield to have a bit of a compounding effect and pay the interest on that loan? And I believed that it was a bunch of people that were being put together, and in the background, I think it was like a peer-to-peer model, like happens on the Bitfinex order book. Which I was very comfortable with as a model, because I was involved in that process. And it wasn't until this happened that I realized that this was all sorts of DeFi contracts and mining and all sorts of stuff. That's why I did it.
Well, I think you guys, the Americans, you guys have to stop doing what you have to get, like, maybe the Africans involved, because what we'll do is we'll look after your money and we'll make sure you get your money. You guys are just a different breed. There's Wall Street and crypto and shenanigans and Luna. I mean, Alex was saying on the AMA, and I never wanted to invest in Anchor and Luna because I knew there was something very problematic with it. And he was telling everyone in the AMA, and I'm like, go Alex, go, yes. We mustn't put our money there. And yet they were behind our backs putting our money there. So, I mean, it's hypocritical. But just you Americans are weird. But I'm just saying, give it to us Africans, we'll look after you.
Okay, well, I'm not American or African.
Hey Simon, so would you say like you just personally, was your investment in Celsius more based on your relationship with Alex than the terms of service? It sounds like, but
I just took a risk that I was willing to take, and I invested in a model that I believe evolved without me having the time or inclination to realize how it was evolving. Because unlike most of the people in the community, I wasn't sat on AMAs every week. I just don't have time to do that. So I invested in something that I thought was just a bunch of people that were willing to pay me yield in order to borrow my Bitcoin, and it was probably done in that way, and that was all being matched up. Okay, another question.
Yeah, can I just follow up on the altcoin question? I've been in crypto since 2017, and I learned the lesson about what happens to alts versus Bitcoin. And I think a lot of people are going to be in that position now, or already in that position, and are stuck holding some of these alts on Celsius, and are going to be forced to watch the value of those go down as Bitcoin starts to recover. So I would say, going forward, I guess I just want to pry more into your plan and see if, and I'm sure this would be something the community would be interested in finding out, like, will you allow users to flip those alts into Bitcoin, like a one-way ticket, into Bitcoin or stable coins as soon as possible? Because like we all have seen, those alts get destroyed by Bitcoin over time.
Yeah, so if you want to know my investment philosophy, and I don't want this to be a promotional, but head over to, I actually created a video series of exactly how I invest. And I invested live on retirementplanb.com. And we built a security law compliant product that was partnering with Celsius, that now will be partnering with a regulated lending platform at the end of this. So that's how I invest. Would we have a feature that allows people to convert their alts into Bitcoin? Yeah, I think we'd look to have that. We are currently in the midst of an application for a virtual asset service provider registration. It would allow us to do that. But if we ended up becoming an exchange in the US, for example, then we'd have to have the equivalent of what a company like Kraken has, which would be state by state regulations and all that type of stuff. So it's more of a regulatory question, and we'd probably sooner partner with an exchange than recreate that type of thing. I know that the current app has like swaps feature, so that's just a whole new set of regulatory investigations that we'd have to do because it's a new business, it's another business line.
Awesome, thank you. And then just one other question, because you speak a lot about, for instance, I have 10 Bitcoin in Celsius. We take a 50% haircut. I'm left with 5 Bitcoin, and then I receive equity in this new company. Now, how does that get valued? Is that a dollar value or a percentage value? And when would that sort of snapshot be taken from? When Celsius filed bankruptcy, or whenever the new plan takes effect?
Yeah, all to be determined. So with Bitfinex, we just had to make a decision. We said, here's the price of Bitcoin dollars, and that's the snapshot. And it was a lot easier then. And then we said, right, there's a $72 million hole. How do we plug that hole? And then we dollarized everything. A similar thing would have to happen here. We can't value our company in Bitcoin. We can only value our company in dollars. And then we'd have to take a snapshot. And what we would probably do is piggyback off what I think the work that Celsius are going to do, because they got us in this mess. So they're going to have to determine the haircut. And then we probably just use their methodology, because we don't want to be accused of, all these unfair practices. We'd probably just say, well, Celsius, you tell us what your methodology is for determining the haircut. And then we'd look to supercharge that recovery plan by a bail-in structure similar to, slightly different from what we did at Bitfinex in today's regulatory environment.
Just kind of getting a little bit creative here, and not trying to say that isn't going to be the answer. But one of the wonderful things about Chapter 11 is the amount of flexibility that the courts have in order to try to effectuate, maximum returns for the success of the company moving forward. Is there may be, I don't know what it is today, but there may be the opportunity for nobody having to take a haircut. If something is put together and there's a viable plan within the right timeline to where everybody agrees that that's the best path forward to emerging without any loss. What that is, I don't know what that is yet, but unlike a Chapter 7 liquidation, where everybody's just stuck with whatever the hole is, there may be a path forward to where that hole can be plugged by a restructuring and reevaluation of Celsius's model in order to make it a profitable ongoing concern, and then nobody loses. That would be the best possible solution.
Yeah, I'll talk to the elephant in the room as well. Oh, sorry, Thomas.
Sorry, what do you mean by a haircut? I mean, I go to my barber or my hairdresser for a haircut.
This is a term of art that means that you're going to receive less value than what you have on the platform. That's what he's saying when he's saying haircut.
I've got to say another word. I mean, it's confusing. I go to my hairdresser for a haircut. I don't understand this. Sorry about this.
Yeah,
sorry.
No, I got you. Look, we're fintech.
And Simon, I apologize. I have to go. I've got a call I have to get on. But I appreciate you having me on. And Thomas, good speaking with you. Plan C, we're chatting a bit in direct message. Thanks very much for entertaining my request. And as always, Simon, let me know if there's anything you need.
Jason, is there anything you're actually, are you like supporting people in class actions or anything? Is there anything you're doing?
Well, right now I do have a client that prior to the bankruptcy filing, I did file an arbitration for them in AAA per the terms of service. So I do have one client that is a company that I am representing. They have applied to be on the creditors committee. It remains to be seen if they will be accepted for that or not. And there is the potential that if they are selected to the creditors committee, that they would appoint me to be their proxy on that committee. So I may be involved a little bit more. What I will say is that my comments today and the comments that I'm making in general when I am speaking on these panels or participating in Telegram are my own comments. They're not on behalf of any client. They're not on behalf of any position. I'm trying to stay unbiased and fair in my analysis of these things to provide complete information for everyone at the time. So
okay, thanks a lot,
Jason. All right, everybody, thanks very much, and we'll chat later. Cheers. Bye.
Cool. Let me cover the elephant in the room. The elephant in the room is sell. And so, again, I'd look to get community feedback. How do you price sell? And I put that out to the community, and people were asking me, how would you price sell? And I said, well, let me put the question back. How would you price sell? And no one came up with a reasonable answer. So no one knows the answer to that. I think we can make some assumptions. If withdrawals were open right now, then sell would be dumped to virtually nothing. That's an assumption, whether that's true or not. And I don't like talking about sell because people might make financial decisions and place trades and short sells and all sorts of stuff based upon the things that I'm saying. And the reason I avoided the conversation right from the beginning is because I didn't want anybody to make a trade based upon what I was saying. And the reason I didn't short, buy, sell, trade, squeeze, anything is because I knew that this was going to, I had a belief that this was going to go into discovery. And if I ever made a financial transaction, then I could be in the same position that Alex is in, where which is a position I never wanted to be in. And I got a lot of criticism for that, and that's probably the number one reason why people have been skeptical about me or firing criticism at me, because I didn't do that, and I'm glad that I didn't do that. and I would end up being a liability like Alex is rather than an asset to the community. So that's why I didn't do anything like that. But how would you price sell? So there's a few schools of thoughts, and I'm listening. I'm listening to the community. There's a bunch of people that I think that there's two types of sell tokens. There's sell own on the app, and there's sell that exists outside the app. I think the easiest way is to treat sell on the app as a depositor. And I know that's not the right legal word, but as a creditor, let's call it. And therefore, it would be treated in a similar way to all other assets. However, there's nowhere near enough liquidity to account for all the sell pressure that I believe would come if withdrawals were open. So there's another argument around, well, there's a lot of people that invested in the ICO, and the ICO was represented to them as equity-like. They thought they were buying shares in the company. It was registered as a security, and therefore, according to Celsius, it is a security. That means that it can't be listed on a cryptocurrency exchange. So my guess is that the exchanges that have listed it right now, unless they've got securities licenses, this will flag up with their compliance teams and they will need to delist. And so, then it becomes illiquid. So how do you do that? Well, I think then it would just come to what is a reasonable way of engaging with the community that I would like to share this journey with us in the future. And if people just think they don't want to be a part of this, then, or there's people that do want to be a part of it, then it would come down to community feedback of what's a reasonable way of doing this. One reasonable idea would be, some people invested in the ICO at 20 cents and 30 cents, and they thought that they were getting equity. Wouldn't it be nice if there was a way of righting the wrong that was made in the past? But yeah, this is just really an open dialogue, and I think it will come out in the committee. And I'd look to see what would Celsius do. And how would they do this in their part? They got their 120 days. What will Celsius do? And then I'd look to say, well, I don't want to be the one that's accused of all sorts of shenanigans. Let Celsius do that. They got us in the mess. Tell us what your model is, and then we'll build a model on top of that, which we think. And that's why we're actively engaging in the process to do what might be right.
Can I add something to what you're saying as well, to the creativity, and also we're saying, and this is and Simon, I think last night when we were getting pretty late in the evening, you basically said this, and then I have a point here, which is you were saying it's interesting to see, like, taking the bankruptcy law and then using these new ways of the community basically to like harvest the best ideas, almost like a decentralized way, like a cryptocurrency would, right? So this is kind of interesting how this is working. And to echo what David was saying, just from a bankruptcy code perspective, bankruptcy, I've said this a few times, so people that have heard me talk, I feel like you can't possibly want to hear anything else I have to say. But bankruptcy code is written in the negative, meaning it tells you what you can't do, not what you can do. So if it's not expressly prohibited anywhere, the judges will allow it. And actually, I said it last night, but I said 105, but I meant to say 501. So 501 of the bankruptcy code, 105, I did it again. 105 of the bankruptcy code is a section that basically allows vest in the court the power of equity, meaning they can basically do whatever they think is equitable, that is not expressly prohibited. And so that part allows you to do all kind of creative things. And so as plans get thrown out there and people start thinking about them, all those negotiations about how to think about it and how to treat it and how to come up with the best mechanism possible are all kind of open season, as long as there's no regulatory issues. And Simon, just to throw this in, because someone was, people are DMing me with questions, so I want to throw it out there. Someone's saying, why not use the crowdfunding laws? I guess this is like the Reg A or the Jobs Act laws. You're probably familiar with those. Those probably don't port to other parts of the world. And I guess the issue would be, I don't know what proportion of Celsius's customers are in the States, but that would only work for a small, believe it or not, subset, which is, I guess, is the U.S. unaccredited investors.
I'll finish off the sell and then go to crowdfunding laws.
Sorry.
Yeah. The sell side. I believe that there's too many regulatory issues for the sell that exists outside the app. And if we announce something and then people start shorting and using that as a speculative tool to try and create an arbitrage on the equity, then I think it would just be counterproductive. So those that are messing with sell on exchanges right now, we wouldn't count that as a creditor, from my understanding of it. And my understanding is that only 93% of sell is either held as treasury or exists on the app as a debt to creditors. So if you want to know how I'm thinking about it, that's how I'm thinking about it. That anything that happens outside the app is traders and speculators, and anything that's happened inside the app is, I believe, people that are victims of misrepresentations. And so therefore, in my mind, I'll be thinking of those people as victims of misrepresentations, and what's a reasonable way of trying to get something that the committee would think is reasonable to those people. So that's there's a big distinction between those that are speculating now and those that have it on the app, in my mind. And I'm open to engagement now. Crowdfunding laws, so I'm very familiar with it. So BnkToTheFuture actually created back in the day the UK Crowdfunding Association that consisted of 3 platforms: Cedars, Crowdcube, and BnkToTheFuture. And we engaged with the UK regulator and spent 3 years getting them to write new securities laws in the UK that created the equity crowdfunding industry. And President Obama actually looked at those rules and the impact of them and created something called the Jobs Act. And then the Jobs Act was taken from that work that we initially did in the UK. And that created this whole industry. Now, the way that they did it in the Jobs Act is very different to how it was done in different jurisdictions. And you have global securities laws. So Reg A Plus, from my perspective, does not globally scale. So when we did a Reg A Plus, for example, Exodus, it was US investors only. And you have to consider non-US, retail in considering how you can use crowdfunding rules. It's complicated, and we do have a lot of experience, but we built it all into our technology called BFID. And BFID takes all of the different nuances in different securities laws and creates a custom onboarding process depending on their jurisdiction. So the answer is global crowdfunding rules in an environment where every single regulator is going to be scrutinizing every move in a hostile environment where there might be lawsuits. It is not going to work. So we've come up with models that we think would work.
Great. Also, I was sort of Googling around, Simon, today. I just was really busy, so I didn't have time to really research this. But 1145A2, just to really get down into 1145, allows you to raise an amount from it looks like unaccredited investors up to their claim amount. So if you have $100, the haircut, to use crypto dude's favorite word, haircut, is 50 cents on the dollar, right? So you have 50 cents in crypto left, and there's a 50-cent hole. It appears that you can do a rights offering for that. We'll call it a deficit, that remaining claim amount. But it also looks like there is a SEC, what's called a no action letter, that allows you. It says the no action letter from the SEC is suggested the amount to be raised cannot be more than 75% of the value of the relevant claim. This is all like bankruptcy nerd stuff. The point is it's very doable. You might not even need someone's question, and even
nice.
Yeah.
Okay, well, we've got a very geeky global securities law team that will be diving into all of this stuff. Any other questions? Okay, I'm going to let 3 more people in if there isn't a question. I'll just take the top 3 people. Oh, there's another question?
No, Simon, I just want to say I think the position on sell is a very fair position. And I think my whole point in this is just the massive amount of education that a lot of people are going through right now. And it's a hard lesson, but a lot of us are going to be learning a lot. And then my follow-up, my last question for Thomas would be, is there anything as a community that we can do to speed along possibly getting Alex removed from the board? I just feel like this is a sticking point that we're kind of stuck with this guy.
Yeah. So, and I think there was a gentleman that we had over the weekend on this. You know, he put it the best way. The word deference. You know, bankruptcy courts showed a lot of deference to debtors, especially when they first show up in court, and they give the benefit of the doubt of trust, unless there is strong suspicions of actual fraud. I don't mean like, hey, illegal security offering, like breaches of fiduciary duty. Hey, illegal, securities offering, all this stuff, selling sell tokens when you didn't tell people you were. These kind of things, I get it, and those are causes of action, but it's not like actual fraud where he took the money and went somewhere. So my point is that that makes it very hard to remove him day one. That doesn't mean he can't burn up his welcome with the judge over time. And I think I had posted this on Twitter, but there are you can file motions to appoint a Chapter 11 trustee, or I've never seen a motion to remove a key executive, but I suppose again, it's a court of equity that the judge can prove anything that he feels it's deemed. I think you'd have to show like material harm for him being in his current position, and my point of view would be, well, he's not really in control. At this point, it's the board and Kirkland running the show, and the activities of the debtor are quite limited and being curtailed by the bankruptcy proceedings and by the estate professionals. So I don't know that there's continued harm that would mean that he needs to be removed. So I don't know.
How about filing something with some form of petition where we get a certain amount of people to sign it, instead of just from Joe Schmo, it comes from 1,000 people signed a petition, saying that they were.
The squeaky wheel gets the grease, but even in bankruptcy court, so it can't hurt. But it's not a formal thing. It would be advisory that the judge would look at and be like, okay, well, wow, okay, that's a lot of people.
Perfect, thank you. You guys can take me off stage now.
Sure.
Okay, another question.
So I'm Rishi. I'm a depositor. I have a loan. I have coins in the custody as well as in the urn. So my question is about the questionnaire for Official Committee for Unsecured Creditors. And in the last question, there is something called written proxy if somebody wants to do it for somebody else. So do you know that, like, is there any specific format for that written proxy? What does that mean? Or can it be simply an email saying that I'm letting this other person to be proxy?
Hey guys, I'm really sorry to do this, but I just realised I've got an appointment now, so I'm going to have to actually drop off. We'll do another AMA. I'm just going to go downstairs and mute myself, and then once that question's answered by Thomas, I'm just going to end the thing.
Yeah, just you really can't have proxies like that. I mean, if you had a company that was a creditor, now the company could appoint either their attorney. Can you guys hear me okay? I'm trying to make sure that my screen's frozen.
Yeah.
Okay. Someone within your company could be on the committee or something like that. And the other way is if you had an attorney representing you, the person would basically need like a power of attorney. I suppose you could actually have somebody, some sort of advisor, be on the committee for you. But it'd be kind of weird. It's not something that the U.S. Trustee's Office would usually like to see or approve, frankly. They would say, hey, thanks for the email. We only like actual creditors on the committee. Unless, you're, let's say Halliburton's a creditor, just making up a creditor name. And, their CFO is very busy. So they put their head of the credit department on the committee. That's one thing for a company. But for individuals, you can't really put a proxy up. You could put your attorney up, I think. That's probably about the only thing you could do.
Okay, awesome. Thanks, everybody. I'm going to end the space now. Thomas, thank you very much for taking the time out. We'll do this again. Where can people get hold of you? Are they just DM you on Twitter? I know you're You've got too much.
Me? Oh no,
Yeah.
I'm always happy to help. For the most part, some people get really, really technical on their actual claim, and I normally give them the general non-lawyer, because I'm not a lawyer, answer, and then I say, here are 2 or 3 attorneys you should call. So I'm happy to do those kind of things, but by all means, hit me up on DM. Happy to try to help somebody.
Okay, cool. So thanks a lot for that. And as a community, let's just focus on solutions. Emotions have been high. I've been going through ups and downs, but I think we've reached the stage right now where most people have come to terms with what's happened. So let's get the best result we can as a community, and let's learn from that, and let's be excited about the process, and leave the lawyers and the regulators to figure out what justice is. And let's try and get the best result for everybody given the current situation. So thanks, everybody. See you on the next one.